Four people arrive at Sydney Airport from overseas. Their circumstances are identical. Each has a valid visa and presents to immigration, but each is put through a different legal process. So how are inconsistent practices allowed if the law is clear? Well, the answer to that question might significantly impact our understanding of how states interpret and abide by international human rights law. Most international law scholarship looks at how lawmaking institutions like courts or legislatures understand and implement international human rights obligations. One theory called Transnational Legal Process, or TLP, argues that these formal lawmaking sites may provide evidence that states abide by international law. But what the High Court or Parliament say should happen doesn't always happen in individual cases. So why do non-compliant practices happen when, according to TLP, they should be corrected by courts or the legislature? And how do those practices shape the development of law? Well, my thesis argues that TLP doesn't account for the often significant influence of low-level officials working within a vast network of institutions where law is interpreted, framed, and applied. I illustrate the argument by looking at how Australia and the United States implement one of the most fundamental obligations of international refugee law, non-refoulement. It's the idea that a state can't turn away or return a person to a place where they would face persecution or other serious harm. The obligation requires that states have fair and efficient procedures to identify and not return those people. Sounds simple, but as the network shows, the reality is much more complex. In Australia, Parliament created protection visas to give effect to the obligation. But as you can see from the network, which is limited to asylum seekers who arrive by air, it's not just up to the courts or the legislature to interpret and observe the obligation. I recently uncovered a Department of Home Affairs policy called entry screening, where border officials cancel visas and pre-screen the claims of asylum seekers who arrive at Australian airports. Entry screening isn't found in legislation or case law, and while the formal legal framework envisions only 3 possible classifications of air arrivals, I've found 4. The fourth happens when a visa is canceled, but the person isn't screened for a protection claim. It exists, it's just not reflected in formal legal sources. Australia insists that it observes the obligation of non-refoulement through policies like entry screening, despite removing the obligation from legislation. But my research shows that low-level officials prioritize visa cancellation and that people are removed from Australia without having their claims heard. Although low-level officials don't generate law, their actions shape how legal questions are framed and answered. And the relational sites within the network of actors responsible for implementation present countless opportunities for contesting meaning in normative frames. That's why TLP must look beyond sites of traditional lawmaking to all the places where law is interpreted and practiced.